we have a special treat today. We have James Gomez with Paramount Title that's going to give us some great educational information in regards to title commitments, question and answer session. So I just want to make sure, can everybody hear me okay?
Yes.
All right, perfect. Okay, let's wait about 5 minutes or so to make sure we have everybody joining us, and then we will get going, and we appreciate you joining us. Thank you so much.
Yeah. It's going in and out for me.
I can hear you.
Great.
ויג, אתה יכול לבוא לראות אם אפשר להקליט את זה? אודיו עכשיו. פשוט שלא רואה את המתקן את המצלמה. וככה אני רוצה את זה.
Okay.
More folks joining us.
Really, that's that.
One more minute, we'll get. Okay, James, are you out there?
I'm here.
All right, great. Well, thank you so much for doing this education class. We really appreciate you. Looks like we have quite a bit of attendees joining us, so this is obviously a hot topic, title commitments, title insurance, all that good stuff. But before we get started, just tell us a little bit about yourself, and we'll get going.
All right, awesome. Thank you, Frank. Thank you, everyone, for showing up today, and or virtually showing up. My name is James Gomez. I'm working with Paramount Title here in Santa Fe. We're a brand new company. We just opened in February. February 1st was our first day of actual operation here in town. I myself am going on 17 years of title, examiner, escrow experience, both here, Santa Fe, Bernalillo, Rio Riba. I mean, you name it, I've searched it. And so we've, started gaining some traction and building our business here in Santa Fe, and just looking forward to really serving the community and serving our customers as best as possible with a new platform and using technology to really serve our customers the best way that we can, efficiently and effectively, holding kind of a new standard for title insurance here in Santa Fe.
Great, great.
Yeah, so what I really wanted to go through with everyone today, and I know it's something that we've all done and seen and looked at, especially in the real estate world, is a title commitment, start to finish. And what I like to call a title commitment as far as a roadmap of an actual real estate transaction. There's several different roadmaps that we have, whether it's closing lender's instructions or a title commitment and even a purchase agreement from real estate agents. And what we do in our portion of that roadmap is the title commitment. And so that's something that I really want to go through and touch base on the different aspects of a title commitment, what it means, and what to look for on a title commitment when you're looking at it. It's just another document that isn't just filed away, when it really means how to get from point A to point Z in a closing.
Cool, great.
Yeah. So I'll go ahead and jump on in. I'm going to do a screen share of just a mock title commitment that I have and that we've drafted here just for today's presentation. And feel free to chime in, anyone, and ask questions as we go. And that way we can, clear up any questions as we go through a title commitment. I'm going to screen share a title commitment that I have, and let me know when it pops up. Can you see it there on your end, Frank?
I sure can. Yeah, looks great.
Okay, great, awesome. All right, so the first page of a title commitment, Schedule A. I'd like to think of this as the actual. I use the analogy of a roadmap, but I like to think of this one as actually the destination. Where we're going to. And on a Schedule A of a title commitment, we have all the details of exactly what that is. We have, if it's a purchase price, you have your loan amount. We have vesting, who actually is vested in the property. We have, the owners. And most importantly, what you're going to have on a Schedule A, everything on this page is very important, but one thing to really, really pay attention to is the legal description. Now, in this legal description, we have it as an Exhibit A to our title commitment. And I will just scroll down really quick through the other pages to get to that Schedule A so we can look at it. But this is really important to pay attention to, because this is actually what's going to bind all the documents recorded to this specific property. So we have in this mock title commitment that we've drafted, it's just a lot out in Windmill Ridge, which is part of Rancho Viejo here in Santa Fe. And so what we do is we base everything off of this legal description. You think of this legal description as a thumbprint, if you will, as you go along the way. It's every property in Santa Fe, in New Mexico that I've searched, is unique. If they're adjoining lots, one right next to another, they're just unique. They're different. It doesn't matter how close or how far they are. Everyone has their own thumbprint. It has its own past, its own chain of title, its own encumbrances. Like I say, it doesn't matter if the one person owns two lots right next to one another, they're still going to be different in some way. So if you think of it as every unique parcel, every unique transaction, this is exactly what we base it off of, which is the legal description. This is usually derived from a recorded plat of survey, and that's how we come up and draft these legal descriptions. Some legal descriptions are just lot and block, as we see here. This one's just a lot as part of Rancho Viejo, Windmill Ridge Unit 3. And some of them are meets and bounds description. Now, a meets and bounds description is a actual calculation and total of all the calls and measurements of a lot as they are shown on a plat. Now, we don't have so much of those anymore, but back in the older, 60s, 70s, that was a fairly common thing to have a meets and bounds description, and they used that to draft the legal description, and that's how they tied properties to encumbrances, drafting warranty deeds, etc. Nowadays, we have a lot of lots. A lot of people, they'll reference a tract A or a tract B, 1 or 2, and in subdivisions you just have a lot, which is lot, in this case 385. So this is a very, very important part of the title commitment, and as it's drafted, this is how it's going to read on all the documents, whether it's a warranty deed, on a mortgage, on a subordination, whatever the case is, whatever's getting recorded, it's going to have this legal description on there, which is going to tie and bind all of those documents to this property. So, something very, very important, something to pay attention to, and something to always keep in the back of your mind, because us title examiners and title insurance people we're good at what we do, and but we make mistakes. So it's always something to look at, and make sure and double check on your end as well, whether it's real estate agent or mortgage loan officer. Just look at it and make sure that everything's in there, because this is just the basis for every real estate transaction. This is what's going to tie everything to that specific property. So we don't want to have the wrong lot number in there on accident. I know I'm guilty of having fat fingers sometimes, and you type in 395 instead of 385, and it happens. So we're all perfect. We're all perfect in our own way, but we make mistakes sometimes. So after going through Schedule A, making sure that all of our numbers are correct, that are on, our loan amounts, our purchase price, our legal description, after we know and have everything that's on there and we make sure that it's correct, the next one is going to be the directions on our roadmap. And this is the directions that a title company is going to be giving you on a title commitment on how to get to closing. I mean, this is exactly what we're going to do and what we need to get done in order to make sure that we can get to the closing table. And a lot of them are going to be similar, but then there's going to be some special requirements on there that are, again, unique as to the property, unique as to, the chain of title, and any encumbrances. And those are all going to be listed here on the requirements page, which is Schedule B, Part 1. Now, the requirements, we have some similar ones, or they're going to be ones that are pretty similar based on the location of the property. So, number one, we have taxes. We want to make sure all the property taxes are paid up to date. We want to make sure, because it's a lienable item, that those are all paid up to the time of closing. We want to make sure that there's no outstanding amounts that are due. We want to make sure that there's, penalties or interest that hasn't accrued on that account. So we as a title company will make sure that we do that research and provide that information on our title commitment. Number 2 here is city sewer and refuse. Now this one it's going to be mostly on all of the city property within the city of Santa Fe, where we require that all of those, because it is a lienable item as well, we want to make sure that there's no outstanding sewer and refuse outstanding on the property. And we want to make sure that all of those are paid. I mean, everyone gets their city sewer refuse bill every month, but we want to make sure that for this circumstance that everything's paid up to the date of closing, especially on a purchase and sale, because you also don't want your new buyers paying for the seller's waste and refuse for the past couple months if they hadn't gotten paid. So again, that's something that we check on and make sure that there's no outstanding. The refinance is a little bit different in the sense that they're just refinancing their home, and there's not a transfer of that debt onto someone else. They are just refinancing their home. They're going to pay their sewer and refuse next month and the month after, even if they haven't paid it current. So we check on it to make sure there's no outstanding. If not, we will collect for it. But if there isn't, then we won't usually make this requirement. If it's out of the city, of course, you're not going to have these issues. We have water wells and septics that take care of the sewer and refuse part of the utilities out in the county. Now, association dues, again, that's something that's unique in the sense that it's only in subdivisions. So subdivisions that have an HOA, and we want to make sure that those HOA dues are paid up, and that those aren't, there's not any outstanding liens that the HOA has filed against the specific lot, and to make sure that we have all those paid up and make sure those are current as well. Now, number four is a very important one, and I'll touch base on number 4 here a while, but we require an improvement location report, and in some cases for the older properties, and when I say older properties, I mean properties that haven't necessarily been insured, or they've just been transferred through the family through years and years and years, and finally someone's going to get a mortgage or they're going to sell, will require a boundary survey. So number 4 will either be our improvement location report or a boundary survey, just depending on what we feel we can insure the property based on. Now, for this circumstance, it's in a platted subdivision, which means that there was a base plat for the entire subdivision that was created. So we're only going to require an improvement location report in this circumstance. Now, an improvement location report is basically a licensed surveyor will go out to the property, and he'll take measurements of all the boundaries, and he'll do a location of any improvements that are on the property. So if there is, the house, of course, chicken coop, maybe a shed, the fence, certain circumstances, everything that's improved on the property, of course, that's why it's called an improvement location report. Now, a boundary survey, and I'll just touch base on that a little bit, is a survey that is done by, again, a licensed surveyor. They go out, they take an entire survey of the property, all the meets and bounds, all the measurements of the boundary lines. But a boundary survey is also recorded. An improvement location report is just for the basis of that transaction or transactions there to follow, owned by the same owner. So if you have an improvement location report and you're doing a refinance, but your ILR, your improvement location report, is about a year or 2 old, just depending on the title insurance company, the title examiner, and their comfort with that improvement location report, they may use it again for a different refinance, whether it's a year, a couple of years after. A boundary survey is recorded, again, with the legal description, and it's tied to the property. Now, of course, people do, add improvements. My wife and I just added an addition to our house, so, we would probably need a new improvement location report at some point to, indicate that, to show that the addition on the home. And a boundary survey is recorded, but it doesn't, obviously, it's not going to evolve with the property. So, me being a title examiner, if I was going to close, I know that I would need a new improvement location report in order to show the new improvements that I've done to the property. And so that's kind of the difference. It just really depends on the title examiner and what we find. Also, the information that's disclosed to us. Now, we can't read minds, although it would be beautiful and wonderful to be able to do so. We can't. So if the borrower or the seller comes in and they tell us, yeah, everything's the same, nothing's changed, then we have no choice but to actually, believe what they're telling us. And we have affidavits that they sign, of course, in order to indicate that. But if, we find out that they've built, a brand new wall, coyote fencing or something along the boundary line, that's going to show it's going to show different improvements, or it's going to maybe it deviates from the property line, then we're going to have to get a new improvement location report to make sure that there's, to make sure that there is no deviation in the fence, or to make sure that there's no gaps that they left, or they didn't build half their kitchen into their, neighbor's lot. So those are all certain things that we need to make sure that are taken care of before we move forward with any more of the transaction, and because that could be detrimental moving forward. Now, the next part of so the first 4 are kind of the standard requirements for title insurance, with whether it's in the city or an HOA, etc. Now, the next part of it are the ones that are going to be more particular for that lot. In this case, we're calling for a warranty deed from one individual to another, just because this is based off of a purchase. Now, sometimes you don't have that transfer of title. Sometimes if there's just a refinance, we're going to call for a mortgage to be paid off, and that's it. But sometimes you also have, in some cases, you have 3 people that are in title, but only one's going to be on the new mortgage. And so what we would do is we would call for a warranty deed transferring title from from all 3 individuals to just the one. And we, of course, would get that document drafted and executed at closing, again with the legal description that's going to tie it to the property. And it's going to be recorded. So the last part here is going to be, in this case, we're calling for a mortgage. Now, sometimes there's not a mortgage. And in Santa Fe, it's a beautiful place, and we attract a lot of tourists from different states and different countries in some cases. And they don't want a mortgage. They just want to pay cash because they can. And so we won't even require a mortgage. We won't, in a lot of cases, it's just they want to pay cash for the transaction, so we don't need it. And necessarily, this is only derived from the information that we get from our roadmap, which is the purchase agreement or closing instructions from the lender. So we won't necessarily make that requirement until we know we're actually going to get a mortgage and have it executed. So that is our roadmap, really, the requirements to our lenders, to our real estate agents that are currently out there, that we're doing business with. This is our roadmap to them. How are we going to get from point A to point Z and make sure that the transaction actually closes? So the last part of the title commitment, which is the exceptions. I'm going to scroll on down here, and there's some standard exceptions that we have, and then of course there's going to be those kind of thumbprint unique exceptions for every property. So the standard exceptions here we have, 1 through 8, excuse me, and then all those thereafter are called what we call special exceptions. Now, 1 through 8 we have, there's some of them that can actually be deleted from the policy, and I'm going to touch base a little bit upon that in the sense that we have rights of claims. Number 1, rights of claims of parties in possession not shown by the public record. So what that really means is we have we do an extensive search of the property, every property that we insure, to make sure that there's a clear chain of title, to make sure that there is no defects in title, meaning that there's not another cousin out there that might have an interest in the property, or grandpa sold the property to someone but forgot and then deeded the same property to his son. That happens, especially in northern New Mexico. We have big families, and we have grandpas and grandmas that own big parcels of land, and they deed it to one son, and a couple of years later they get mad at that son and they deed it to another son. And we've seen it plenty of times. And then we go to insure title, but we realize that there's actually 2 people holding title of that property, or there's a defect because grandpa and grandma have now deeded that property to 2 different individuals. And so what we do is we go through, we make sure that all of that is taken care of. Now, this exception is based on parties in possession that are not shown by public record. So in this case, there's sometimes that people will get a warranty deed from, in this scenario that I'm working off of, is they'll get a warranty deed from their grandparents and they'll never record it. They'll never go down to the county and record it with that legal description, and they will put it in a shoebox under their bed, and it stays there for years and years and years. And we obviously can't predict those types of situations. So that's what this exception is based on. It's, those warranty deeds that are hidden under someone's bed in a shoebox or in someone's drawer that just never got recorded. Of course, we wouldn't know that they exist until they are recorded down at the county, and, put a public record. This next one is easements or claims of easements not shown by the public record. Now, this kind of plays hand in hand with number one. Number two here is an easement. Grandpa has let his neighbor drive through his property with a 15-foot, corner of his property for the past 20 years, and he's never had an issue, but they've never put anything on paper. They've never created a legal description for this easement. They've just always allowed it to happen. And now, Grandpa sadly has passed on, and grandson owns the property now, but wants to put a fence. That way no one can drive through that 15 feet anymore. Well, this is going to be part of the claims of easement portion of this exception, because there's no way that we would know that Grandpa let him drive through there for, X amount of years. And so we need to make sure that we as well cover ourselves, but also get aware to the sellers or borrowers that, we can insure easements that aren't of public record. Now, I wanted to call special attention to the improvement location report and the boundary survey, because number 3 kind of plays into that. The encroachments, overlaps, conflicts in boundary lines, shortages in area, or other matters which will be disclosed by an accurate survey inspection of the premises. So this exception we make because if someone puts up a fence and it meanders along the boundary line and it goes in and out and sometimes into the neighbor's lot or tract, and we need to make sure that we address those issues before closing, or we have to take exception to them in a special exception based on that boundary survey or the improvement that shows those improvements. Now, just for instance, I did a title exam search on a property in Nambe, the Nambe area, and the gentleman built a beautiful addition to his home, and it was just extravagant. But the kitchen was lying about 10 feet into an easement, and it was a public easement that was actually would turn to be a county road. And we would have never known. We would have never known because he didn't tell us anything until he started talking about all the work he was doing on his house and that addition that he built onto for his kitchen. So we ordered a boundary survey, and sure enough, that kitchen was in someone else's property. And it turned out that we had to rectify that issue before closing, because that was a big issue. Now, we don't always run into that. A lot of times it's a wall or a coyote fence or someone's driveway that they've paved. And then those are fairly small issues that could be resolved fairly quickly. But when you build your kitchen in someone else's property, it's a little bit more of an issue. But those are all shown on a survey or a improvement location report, which is something we need. Otherwise, we have to make a special exception for it. So this one just shows, it kind of is a coverall for us as title insurance agents, but also for the new owners or even the borrowers, to just help remind them that, look, we need to have all the information before we move forward to closing. The number
James,
4.
Quick question for you.
Okay.
Melissa is asking, so in that situation where you have this gentleman that built his kitchen on somebody else's property, give us a quick example on how that could be resolved.
So there's actually a couple ways. What we ended up doing is we got an easement for this kitchen. So the property owner that was adjacent was actually the Huaquí Pueblo. And so they can't sell the property. I mean, that's just kind of part of the federal rules that they have to abide by. Once a Pueblo takes ownership of a property that is adjacent to or close to their Pueblo grant, it goes into trust, and they can't sell it. They just can't. It's part of their one of the rules that they have. But what they did is they granted an easement to this gentleman for that specific parcel of property. Now, the gentleman had to get a boundary survey of this triangular piece, which his kitchen was built on, and they did an easement for him, and he pays, I think it's like $25 a year to have his kitchen on there, and he pays the Pueblo, which the Pueblo was really, generous in working with him to get that done, because they could have just, said tough luck and that's it. Now, in other circumstances where there's private owners and there's a certain circumstance like this one or a situation like this, then they a lot of times private owners will just sell them that piece, and that's one other way to get that issue rectified. So there's a couple of options, an easements or or just a sale, but a lot of people don't take the importance of just putting things up, especially in northern New Mexico. I'm from northern New Mexico, so I can say this freely, but we tend to just build things. We build them and not pay attention to where boundary lines are, or oh, that's Uncle Joe, and he's not going to worry about my shed being halfway on his property until Uncle Joe sells to someone else, and they care about that shed being halfway on their property. So those are all issues that arise, especially when we're doing searches up north. Like I say, we just tend to build things when we have spare time, and for whatever reason, not really pay attention to a lot of the boundary survey issues that might arise from it. Now, everyone's getting more educated now, and so boundaries and boundary lines are definitely something that's very important to people. But there's still a few of them out there that just want to put up a place to put their wood for the winter, and they don't realize that they're actually putting on their neighbor's lot. So yeah, there's to answer your question, Frank. Yeah, there's a couple of ways that we can issue that, or rectify that issue. It's just going to be a matter of which way is preferred. Yeah.
Okay.
So the next one I'll go to is number 4. Any lien or claim of right to a lien for services. So what we'll do is, as a title insurance company, we have a document, a mechanics and materialman's affidavit that we have all of our customers sign, whether they're sellers, borrowers, buyers, and especially in a sale transaction, this is very important. Now, this exception can be deleted with that affidavit. So we will insure based on what our customers tell us. Now, in this circumstance, it would be as if someone's getting ready to sell their house or put their house for sale and list it, and they hire a painter or they hire a plumber or an electrician to come in and just do some touch-up work, or fix a plug, or maybe fix a sink that's been kind of backing up before they put it on the market, because they want their house to show well and they want it to sell quickly. So a lot of times you'll have those types of circumstances, or a roofer come in and patch a ceiling for a small leak or something real quick, but then they say, well, I'll pay them when the house sells. Well, the house doesn't sell for a month or so, and then this contractor gets upset and goes and files a lien. And they file a lien down at the county saying, hey, look, I never got paid for my services. Sometimes they don't file a lien, but they expect their money. And some sellers, they'll go out and they'll sell the house, and they just will forget that they hired that painter to paint the entire home. Then, after the house is sold 2 weeks, 3 weeks later, there's a lien of record, and that lien is for the painting of this home. Now, one thing that when we have them sign this affidavit is that there hasn't been any construction in any way to the property within 120 days. And the 120 days is the amount of time that it would be for a contractor to go in and file a lien based on their services. So we want to make sure that everyone's telling the truth when they're selling these properties, but they're also making sure that all their debts are paid that are attached to the property. And if there is, then let's say there is a scenario like that where someone's listing their house, they hire a painter, but they tell them and then agree with the painter that they're going to pay them when the house sells. The painter's okay with that. Now, I've never seen that, but you know, it could happen, I guess. What we'll do is we will get an invoice from the painter for the property. We will collect those monies that are due at closing, and we will cut him a check before we issue the seller their proceeds, just to make sure that everyone's gotten taken care of and that we are not going to experience any of those issues after the fact that we might be responsible for as a title company, a title insurance company, and making sure that, you know, there's no debts that are passed on to the buyer or borrower. Now, borrowers tend to not get a lot of this stuff done before they go, you know, get an appraisal, I guess, for a mortgage. Maybe they might patch some things up or do some DIY projects themselves to kind of spruce up the house before the appraiser walks through, you know, clean it up a little bit. But not anything that's going to be of detriment or going to be a lienable item. Now, it happens, there's sometimes that people do get stuff done, not realizing that it's going to impact their mortgage or have this type of issue where we're going to have to get that those services paid for before closing or at closing. So that's something for borrower or for lenders to take it, you know, into consideration, or maybe let their borrowers know that if they're going to get anything done, they need to make sure that they have a invoice that's marked paid, or that they just wait until after closing. I mean, it's kind of one of those things where we don't want to make sure that they're putting themselves in a position to where they may not be able to get the mortgage or title insurance done correctly because, or not correctly, but just not done at all because they've gotten these services done at their house. So we need to make sure that we get all the documentation that it's been paid, or that we're going to pay it out of closing. One of the two, but we need to make sure before closing or at closing it's paid before we record anything else. Now, the next one, community property and survivor of homestead rights. Now, I've never ran into this in all my years of doing title insurance. I've never had to deal with number 5, and I'm sure of the owner of Paramount Title, who's a real estate attorney, has had to deal with probably community property or maybe even homestead rights, Tom Banner. But I have not, thankfully. I think that, this is probably just a kind of a catch-all. Someone gets married and they purchase a property while they're married, and then they get divorced, but they've only held title alone, and then they get married again. And I really wouldn't see in a situation where number 5 would really be it would be a huge detriment not to have that on the as an exception on the title insurance policy. Now, number 6 is a big one again, especially up north in northern New Mexico, and in New Mexico completely. Water and water rights are huge, but in northern New Mexico we're finding, because people still go out there and they plant their garden and they have these ditches that run through them. The water rights are a big deal, and there's the Admont water suit, which has taken place for 60, 70 years, I believe already, which affects a lot of the Chisuke, Poake, Nambe, Rancho area, and it's a conflict between the pueblos, the tribal pueblos, and the private owners of water rights of properties, where the pueblos are saying, okay, well, we own all of the water under the land, but you guys own the land. And so there's been some dispute about that. I think there was some type of resolution to where there's just going to be a huge water system now that's going to be implemented, but that's going to take a few years. I think they're estimating 5 to 7 years before that's actually done. Water rights is something that's huge in northern New Mexico, so it's and there's a lot of dispute over it, and you'll hear from spending enough time around the guys out there planting their gardens that they're angry because someone else got their water before them and they didn't get to water their cucumbers this week. It's a big deal. So that comes into conflict a lot. So that's something that and title insurance does not insure water rights, period, because water rights actually have their own title. So you could deed off a piece of property, but retain the water rights. And a lot of times, especially in the older warranty deeds, you'll see that people deeded off the property. You can have the property, but I'm keeping all the water rights that are attached to the property. And so it then creates a break in that sense that there's water that has their own chain, and then there is property itself with the legal description that has its own chain of title. So that's something that we do not insure at all, is water rights. And then we're going to kind of get down into the nitty gritty of it here, which is the taxes. You know, we're not going to ensure that the taxes are going to be paid anytime after this year, you know, after closing, whatever it is. We can't ensure that the owner is going to go down and pay their taxes, or the mortgage company is going to, you know, set aside escrows and make sure that that mortgage is getting paid. A lot of times that's the case, but we can't, as a title insurance company, you know, predict the future. So we have to make sure that we have that exception in there for the taxes after what we take care of. And what we take care of is everything in arrears. Now, defects, number 8, defects, liens, encumbrances, adverse claims, or other matters created appearing in the public record. So we're taking exception to everything that is, again, in the future. We can't make sure that there's not going to be that painter that sets a lien out there in 6 months, where we can't make sure that there is going to be we just can't read, you know, we don't have a crystal ball. That's our, number 8 is our crystal ball exception. We can't look into the future and predict what's going to happen, or if there's going to be any lien subsequent to the date that we close and we issue the policy. So that's something that we have to have in there, because there's been times where people come and say, well, you guys are my title insurance company, you guys should take care of this lien. Well, it happened 2 years after we closed. We would never know that lien's going to take place. So that's number 8, as I like to think of it, as our crystal ball exception. And so after number 8, and I'll go through these fairly quickly because these are all just unique. These are our thumbprint exceptions. These exceptions are just unique to the property or to the subdivision that we're working in. The restrictions, we have these restrictions here. We take exception to those because we can't make sure that, and we can't, again, predict the future, that someone's not going to violate those restrictions that are set forth. We're not going to be able to ensure that someone in Rancho Viejo or El Dorado isn't going to paint their house pink. You know, that's just something that we can't do, and that would be a violation. And in El Dorado or Rancho Viejo, they will come with you with torches and pitchforks if you paint your house pink. No, I know, but yeah, and cameras, yeah. But yeah, these are all just really thumbprints, unique to the property. You got restrictions, you got bylaws. You know, a lot of what is here is going to be important for real estate agents to go through with their buyers, because they want to make sure their buyers know what those restrictions are. We want to make sure that their buyers know that they can't paint their house pink or they can't build a fence. And that might be a deciding factor for those buyers. So a lot of these exceptions, which we provide with our title commitments, we provide copies, digital copies, or printed copies if needed. They could look through with their buyers and make sure that their buyers understand what they're actually purchasing. You know, you're buying the property, but there's a lot of these other restrictions that are going to keep you from doing what you want to do. So that's basically 9 and 10 for this property. Now, sometimes there's 15 special exceptions, and that's all based on the title exam itself and what's found. Sometimes restrictions are that the property can't be sold for another 10 years after the first sale. So that's something that we would have to address and make sure that the buyers know that and make sure that everyone's in agreement with that. A lot of times, and one thing to mention now that we're kind of wrapping up a title commitment here is you'll never have, not from me anyway, you'll never have a title commitment that has something that is required and accepted to all at once. So I won't make an exception to a document, but then also make a requirement for that document. I'm either going to make a requirement to satisfy it, and if it's not satisfied, then we'll make an exception to it. I think that should be standard practice, and I believe it is, but it's one thing to make sure that you look for, because if they're putting an exception for access in this case, but they're also requiring access, but then you fulfill the requirement for access, then you still have an exception on there. It's kind of a double-edged sword. So it's one thing to pay attention to the requirements and the exceptions, make sure that everything that is needed to satisfy the transaction and to close is in the requirements, but also everything that everyone needs to be aware of, restrictions, etc., are in the exceptions, and that they're not they're not in both areas. Now, this last one is pretty common on most, if not all, title commitments. Most, if not all, title commitments that I've done. Notes, easements, and rights incident there too, as shown on the plat. So we're accepting to anyone violating any of those, notes. Sometimes there's special notes on the surveys when they get the boundary survey done. There's a note that says, their P&M is going to install utility lines along the front 5 feet, but there's not an actual easement for it. There's just a note on that. There's just a typed note on the plat that says that. Sometimes there's easements that are on there. We want to make sure that we as a title company accept to those, because we're not ensuring that someone's not going to park their fifth wheel on there and block that easement, and then we would be responsible for that. And then this last one is again just a really special exception for that based on this property alone, and this one is just for an easement that is recorded in Santa Fe. And again, it's just we want to make sure that we're accepting to and making sure that we take care of that. I'll give one scenario of this before I wrap up here. We did title insurance, not here, but in a prior company that I worked for. We did title insurance on a house on Canyon Road, and the easement was not accepted to on our title commitment, our title policy. And there was this really lavish owner on Canyon Road that ordered this specific stone from Spain or somewhere in Europe, and they did their whole driveway, $750,000 driveway, with this stone, $750,000, and that easement wasn't accepted to, but the gas people had to come in and redo the gas line, and that was the easement. They had an easement to go in there and tear up 15 feet of that specific, $750,000 stone. And this title company that I worked for had to cover the cost of, thank God they didn't go in there with a backhoe and just tear it up. We had to cover the cost of removal of the stone and the trenching they had to do under, and then the replacement of the stone back into its place. And so that was, as you can imagine, quite a bit of money. But those are the type of situations that we cover as a title company, and the liability that we have when we're insuring these properties, is that no matter how big or small, we're kind of putting our necks on the line if we don't do a good job for our customers. So that for me actually is I'm wrapped up on the title commitment, and if there's any questions, I will be glad to take them.
Yes, please. Well, thank you, James. I mean, that was super informative. I mean, for me, I've been doing this for quite some time, and I got some really good nuggets out of that. So thank you so much. If you have any questions, you have a couple of options. We're going to unmute the lines. Of course, you can ask the question. You can also write up a question in the chat box or raise your hand. For the guests that are with us today, if you don't mind, we'd love to just have your information. So if you could just type out your of course, your name and your phone number, your contact information in the chat line. James, it would be awesome if you could do the same thing for us. So our real estate agents that are here joining us could have your information. Of course, you could just tell us what's the best way to get a hold of you too.
Well, the best way and easiest way to get a hold of me is via email. James at ParamountTitleNM.com. And I'll put that in the chat box as well. You could give us a call, 505-772-0303. That's our main line number. And or just come on in. Our address is 2100 Calle de la Vuelta, Suite E04. Now, of course, we have everyone's got to wear their masks. We're still abiding by the governor's rules. But if you want to stop on in and just take a look at our office and meet with us, we'd be glad to do so. And I'll go ahead and put all that information into the chat box as well.
Great. And I can tell you from experience, we kind of, here at Gateway Mortgage, we first had the opportunity to work with James and their team, I would say a couple of months ago. He was the title company on one of the transactions. We were handling it. And, I hear from my team, a processing department or my assistants, James and his team were just on it. So I think it was, a couple of weeks ago you came by. We had some lunch. We had some great discussions. And we've been getting quite a bit of refinances, and we've been using James and Paramount Title to handle some of those title insurance commitments for us, and they have just been great, awesome, very, getting us what we need quickly. And in this business, speed and efficiency is very key. We never ever want to miss a closing date, and having a great title company supporting us, supporting our buyers agents, the listing agents, the buyers themselves, is just critical. It's critical. If we have one weak link in this whole chain, it slows everything down, and we could miss a critical closing. So you guys are doing amazing, James. Congratulations on the new title company, and thank you for doing this great class. I mean, for me, again, got some great nuggets out of it. I don't see any questions here in the chat box. But I'll ask you a quick question. In a nutshell, kind of give me what title insurance is, what it does, and what it protects.
Well, title insurance protects everyone that